Hey, welcome. You've seen the heist movies, right? You've got the mastermind, the muscle, the tech whiz, the getaway driver. But what happens when the plan goes south? How does the law actually figure out who's to blame for what? Well, today we're going to break down exactly that, the legal concept of parties to crime, and see how the justice system assigns responsibility when a crime is not a solo act.
Okay, so let's just dive right in with the big question. Picture a bank robbery. You have the person who planned the whole thing, the one who actually cracks the safe, the person acting as a lookout, and then the friend who hides the crew at their house afterward. Are they all on the hook for the exact same crime? Well, the answer, it's a lot more complicated than you might think. So to really get where we are now, we've got to go back in time and look at the old common law system. You can think of it like casting a play. It divided everybody involved in a crime into four really specific and, really rigid roles. So let's meet the cast, shall we? First, you had the principal in the first degree. This is the doer, the person who actually pulls the trigger or snatches the money. Then, the principal in the second degree. That's your lookout, someone who's right there at the scene helping out. Next up is the planner, or what they called an accessory before the fact, the person who supplies the blueprints but isn't actually there. And finally, you have the helper, the accessory after the fact, who swoops in to help after the crime is all over. Sounds pretty logical, right? Well, it ended up creating some major problems. The biggest headache was that this old system was just a procedural nightmare. Get this, you couldn't convict an accessory, so the planner or the helper, until the main doer had already been convicted. So what if the main guy got away? Well, then everyone else could just walk free on a technicality. Even if you had rock-solid evidence they helped plan the whole thing, these rigid categories just didn't hold up in the real world. Okay, so the old way was a mess. How did the law evolve to fix all this? Well, to get rid of those loopholes and technicalities and just focus on who was actually to blame, most places moved to a much more streamlined, modern approach. And this slide just lays out the simplification perfectly. The modern approach basically took those first three roles, the doer, the lookout, and the planner, and just collapsed them into two main groups, principals and accomplices. And that person who helps after the crime, they're now dealt with in a completely separate way. So what exactly is an accomplice? Well, take a look at this definition. It's anyone who helps or encourages a crime, either before it happens or while it's going down. And here is the absolute key takeaway. Under modern law, accomplices are treated as if they committed the crime themselves. They're equally liable. The lookout is considered just as guilty of robbery as the person who actually took the money. Okay, let's get into the weeds a bit, because this is where it gets really interesting. It's not enough to just be hanging around when a crime happens. To actually be an accomplice, the prosecution has to prove two very specific things, a physical act and a mental state. First, there's the physical part, what lawyers call the actus reus. You have to actually do something to help. Now, this can be something obvious, like physically handing someone a weapon, or it can be more subtle, like acting as a lookout, which gives a kind of psychological boost to the main offender. Now, this raises a classic legal question. What if you're just standing on a street corner and you watch a crime happen? You don't help, you don't say a word, you just watch. Are you an accomplice? The law is very clear about this. And here is the answer, straight from a landmark Supreme Court case. Mere presence is not enough. Even if you're secretly hoping the criminal gets away with it, that uncommunicated intent is legally worthless. To be an accomplice, there has to be some word or act that actually helps or encourages the crime. You have to participate. Now for the second piece of the puzzle, the mental state or mens rea. And this is where it gets tricky, because for an accomplice, it requires something called a dual intent. A prosecutor has to prove not just one, but two things about what was going on inside the accomplice's head. That's right, the prosecution has to prove two separate layers of intent. First, that you intended to provide the help. You meant to hand over that crowbar. And second, that you did it with the intent that the actual crime, the burglary, would actually happen. This slide brings up a fascinating point. The law separates your intent from your personal motive. In this classic case, a judge hated this guy named Ross and knew some other men were out to kill him. Someone tried to send Ross a warning telegram, but the judge sent his own telegram to make sure the warning never arrived. Now, his personal motive was pure revenge, but his legal intent was to help the killers succeed, and that's what made him an accomplice to murder. So, we've covered helping before and during a crime. But what about helping a criminal after they've already made their getaway? Well, the modern approach treats this very, very differently. This is that separate and usually less serious crime of being an accessory after the fact. If you look at the elements, the key difference here is all about timing. The main felony has to be finished before you give any help. You have to know a crime happened, and then you have to act specifically to help that person avoid getting caught. Okay, so we've got all these rules, right? Principles, accomplices, accessories, actus rea, mens rea. How does a lawyer or a judge actually take all this and apply it to a messy, real-world situation? Well, believe it or not, there's a method to the madness. And this flowchart right here, this is that exact method. Professionals use a step-by-step process like this one to untangle everyone's responsibility. It's the logical framework for figuring out who's on the hook for what. So let's just break that down real quick. First, you identify the main player and the main crime. Second, you look at what the potential accomplice actually did. Third, you evaluate their state of mind, that tricky dual intent. Fourth, you decide if they're liable for the crime they helped plan. And finally, and this is a big one, you have to figure out if they're liable for any other crimes that happened along the way.
All right, let's put this framework to the test with a quick scenario. We have Dan, he's our principal. We have Paula, who helps him before the crime. And we have Fred, who helps him after. Let's figure out who's liable for what.
First up, Paula. Dan asks for a crowbar to get some money, and she gives it to him, knowing full well what he's planning. Is she an accomplice to the burglary? Let's run it through our framework. The actus reus, the physical act? Yes, she provided the crowbar. The mens rea, the mental state? Yes, she knew he was going to commit a crime and she intended to help him, so she is absolutely an accomplice to the burglary. But what about Dan hitting the guard? Paula didn't intend for that to happen. Turns out it doesn't matter. Under something called the natural and probable consequences doctrine, she is also liable for any other crime that was a foreseeable result of the plan, and violence is definitely a foreseeable result of a burglary. Okay, now let's turn to Fred. Dan does the crime, leaves, and then he goes over to Fred's house and asks him to hide the evidence. What's Fred's role in all of this?
Fred's actions all happened after the burglary and battery were completely over. He knew Dan had done something bad, and he acted specifically to help him avoid punishment by hiding that crowbar. He is not an accomplice to the original crimes. He's guilty of that separate and lesser crime of being an accessory after the fact.
So we'll leave you with this thought. Your friend tells you they're about to go steal something. You don't give them a bag, you don't act as a lookout, you just say, "Good luck." Is a simple word of encouragement enough of an act? Do you have that dual intent? Based on everything we've just covered, that one small phrase could be enough to make you a party to the crime. Something to think about.